It is the appointed time and we have a quorum. I will now invite the administration to come into the room.
我哋今日有歐韻詩女士。
In attendance today, we have Principal Assistant Secretary for Environment and Ecology, Ms. Wendy Wu, Ms. Wendy Au, Deputy Secretary, Ms. Ivy Law, Assistant Secretary, Mr. Philip Mack, Head of the PCAO Private Columbaria Affairs Office of the FEHD, Ms. Charmaine Wong, Mr. Francis Zhang, Assistant Director of the FEHD, Mr. Jonathan Luke, Senior Assistant Law Draftsman, and Mr. Jonas Wong, Government Counsel.
Hello, 早晨，早晨。咁樣上次開咗會之後
Since the previous meeting, the Secretariat has uploaded a notice onto our website to invite public submission for the bill. 3 submissions have been received. The same have been uploaded to the website as well. The written reply from the administration is set out on paper CB-3243 2025-02. I will now invite the administration to walk through the reply. Good morning, Chair. Good morning, members. First of all, I'll reply on the submissions. I will briefly go through the paper. First of all, we have received 3 submissions. We thank the supporting views on our mechanism for applying for a specified instrument. Now, there are 3 suggestions set out in the submissions. First, 2 operators of pre-cut-off columbarium suggested that the new exemption option be applied to operators of pre-cut-off columbariums which have obtained a license or obtained in principle approval. Now, the PCAO under the FEHO have reached out to the 2 operators to understand the rationale behind their decision. It was found that there was a misunderstanding. The 2 operators misunderstood that concerning the niches sold between 8 a.m. 18th of June 2014 and the 30th of June 2017, if a new application is filed, the land regularization cost can be waived. That's why these 2 operators would like that the new options be applied to them as well. Now, the PCAO has clarified the matter with the 2 operators of pre-cut-off columbarium. That's the new application for exemption proposal for pre-cut-off columbarium. The short-term waiver fee or short-term tenancy fee still applies. In other words, the arrangement is the same as an application made for land regularization. In order not to give rise to unfairness, we will not extend the proposal to pre-cut-off columbarium. Now, for new applicants, since a license has not been obtained yet, they are also covered by the waivering requirement. We have explained the matter clearly to the 2 operators. The other matter is that for pre-cut-off columbarium, what is the arrangement for amending the lease? Now, for lease amendments in relation to pre-cut-off columbarium or land regularization arrangements, this is not a mechanism under the bill. and has nothing to do with the bill. Because of Columbaria, applying for a license may, in accordance with its operation plan and the actual situation, choose to apply for a lease modification with the land department or apply for land regularization. Now, there are two arrangements under land regularization. For example, they are STT, short-term tenancy, and STW, short-term waiver. Now, we are aware that the applicants understand that the maximum tenure for a lease is 10 years, and also an interest would be imposed on the applicants according to the land premium. For land regularization, the applicant needs to pay the fee according to the government's policy. Now, in terms of paying fees by installments for short-term tenancy or short-term waiver, let's say the tenure is 10 years, and the applicants would like to exclude parts of the niches in calculation of the fee. Now, in that case, since short-term tenancy and short-term waiver charge the fee per year, and also there is no requirement on the applicants on when to sell the niches, so the applicants can make a decision on sale based on his business plan. Third, about publicity. There are views that we should step up publicity, and this is something that we promised to do. Subject to the passage of the bill, we will issue a press release, and also through the dedicated websites of the FEHD, we will make relevant announcements. And also case managers under the PCAO will reach out to the operators one by one to explain to them the details and help them decide whether they would opt for the new exemption specified instruments pathway. Thank you. Now, further information has been provided by the government through CB brackets 3237 and 243 2025-01. I will also invite the administration to walk us through the papers. Concerning the list of follow-up actions, this is about the provision of number of private Columbaria inspected, number of cases convicted, and offense involved, and how we can speed up the enforcement process. I will invite the PCAO to explain the document. Head of the PCAO, Ms. Xiaoming Wong. Thank you. Since the ordinance has been enacted, the PCAO has conducted some 3,200 inspections on the Columbarium. For suspected contravention, the PCAO has conducted investigation and enforced the law. By the 31st of December 2024, the PCAO had prosecuted the operators of 11 Columbaria, all for operating a private Columbarium without a license, that is contravening Section 10 of Cap 630. The operators in 10 of these cases were convicted with a fine ranging from $2,000 to $30,000. A criminal record was also registered. On the question whether we have issued enforcement notice under Section 64 of the law, we have. Now, there was a licensed Columbarium, the operator of which have breached a condition imposed by the Private Columbaria Licensing Board relating to unauthorized alteration works. So one enforcement notice was issued. Upon receipt of the notice, the operator took remedial action promptly. Now, since a response has been given in a timely manner, we haven't prosecuted the operator. However, a warning letter was subsequently issued. As for Section 54, which imposes restrictions on the number of sets of ashes kept in private columbarium, there has been no contravention identified since the ordinance came into force. Thank you. Also, on the 15th of January, the legal advisor has sent a letter to the administration to inquire of matters. That is paper CB 368, and a reply has been given via CB 3237. I will invite the administration to cover the reply when we conduct clause-by-clause scrutiny. Now, we were still at the policy matter of the bill. The last time, there were two members who have raised their hands and had not yet spoken. They are Mr. Ambrose Lam and myself. Does any other member have questions on the government's reply and also the follow-up actions? You may also raise questions on policy matters of the bill. Please press the request to speak button if you do. I will now invite Mr. Ambrose Lam to continue. Thank you, Chair. Now, about public columbarium, the government said that there are sufficient places. I also see that the columbarium in Chun Mun and Chang Kwan O are of a large scale. They are very spacious. Now, the government has a difficult fiscal situation. Now, can we ensure that the fee we charged can recover the cost? Now, compared with the registration system of private building and registration system for niches, will the government consider establishing a registration mechanism for niches as well? I have put forward a recommendation to the Financial Secretary for the budget whether stamp duty can be charged on niches. Now, when the niche is purchased, usually they are sold individually. So let's say the father in the household has passed away, a niche has been bought, but when then the mother passed away, there is no free niche next to the father. So there is not a so-called buy or sell system in the market. It is entirely up to the operators of the columbarium. So it seems that we need a free market for this. Ms. Law? Thank you, Chair. Thank you, Mr. Lam. Concerning the fees charged on public niches, the government does review our fee levels from time to time, so we will make reference to Mr. Lam's opinion when we conduct a review on whether we need a registration system for niches. Currently, all information of the operators of columbarium has been uploaded onto the dedicated website of the PCAO. The website disseminates information on the number of available niches and so on. Now, of course, Mr. Lam's suggestion was even better. But to establish that system, it would come with significant cost. So we would like to keep the current system running and review the system when more columbarium are set up.
林議員仲有冇其他跟進？
Mr. Lam, any follow-up question? No. Mr. Tony Chair, each member will have 5 minutes, including question and answer. Mr. Chair. Thank you, Madam Chair. I'd like to follow up on the government's reply to the meeting on the 24th of January 2025. The reply, paragraph A. Over the past 7 years, we have on average conducted 400 inspections per year. The fine ranged from $2,000 to $30,000. Under this bill, we want to talk about whether we should increase the level of fine. In light of the prosecutions initiated by the government, can the administration let us know if they will adjust the ceiling? Has the level of fine anything to do with the number of prosecutions? For operating a private columbaria without a license, well, fees are involved. What is the proportion to the level of fine? That's my first question. Second, on Section 64, enforcement notice, it is said that an operator engaged in authorized alteration works. What kind of works are we talking about? You said that you didn't initiate prosecution. Did the operator resume the Columbaria to its original condition? Deputy Secretary, thank you. Let me first talk about the fine. As for the Section 64 enforcement notice, I will ask the PCO to supplement. 10 of the cases were prosecuted. For Section 11, the maximum penalty is $2 million in imprisonment for 6 months, and for conviction on indictment, the maximum fine is $5 million in imprisonment for 2 years. But then the court will hand down a fee according to the nature of the case and severity of the offense. So the fine that we have seen ranged from $2,000 to $30,000, as it was a criminal offense, so criminal records was registered. Let me now ask the PCO to talk about the enforcement notice. Thank you. Regarding the case about Columbaria installing an environmentally friendly incinerator. Well, but according to the enforcement notice, as long as the operator take remedial action, we're not going to prosecute them. Upon receipt of the enforcement notice, the operator actually removed the incinerator very swiftly. Madam Chair, as the maximum fine actually handed down was only $30,000, this is a far cry from the ceiling set out under the legislation for this offense. So what is the government's take on the fine and the level of penalty? Do we have to increase it, or do you think that is enough? Because at the end of the day, it's the judge who makes the decision. Thank you. Can the government tell us about the background of the case? I will ask the PCO to give you some details of the case. Mr. Chang. Thank you. Let me give you more details about the case. All of the 10 cases have to do with illegal selling of niches. So according to Section 10 of Cap 630, they breached the offense of operating a private columbaria without a license. As mentioned by the Deputy Secretary, the level of fine handed down was heavy. While we and the court play a different role, in the amendment, we think that the current level of fine is appropriate. And in the bill, that's why we do not propose to make any amendment, because we think that the fine should be deterrent enough so that the operators will not breach the law. We think that the current level of fine is appropriate. One more word. Can I take it that the administration think that the fine under Section 10 and 11 are deterrent enough, because the highest level of fine handed down is only $30,000. But I wonder how much the Columbaria earn by selling niches and what is the proportion. If the government thinks that is fine, although the fine is as low as $2,000 to $30,000, despite the huge amount of profit that the Columbaria earn, it seems that the government thinks that this is okay and it will not happen again. Thank you. The proportionality. Ms. Law. Thank you. We don't think that the fine handed down is okay. What we meant was that under Section 10 and 11, offenses for operating a private Columbaria without a license, the maximum fine is $5 million and imprisonment of 7 years. We think that this level is deterrent enough under the law. That's why we do not propose to amend it. But if the fine handed down by the court is too low, we do have a mechanism to lodge an appeal with the court. We'll continue to leverage on this mechanism. And in our paper submitted to the court, we talk about the level of importance that we attach to such offenses. The maximum fine is $5 million and imprisonment for 7 years, but the court makes the professional judgment. But if the government thinks that the level of fine and penalty handed down is too low, we do have a mechanism to lodge an appeal. Thank you. Mr. Chair, any other follow-up question? No? Well, there's no adjustment to the penalty. I believe that the administration have looked into the 10 cases and they thought that the level of fine is appropriate. I don't want to see such cases happen again. Let me give you a suggestion. I wonder if the FEHD work on the prosecution, if you outsource it to the DOJ, will you give more guidance to the prosecutors such that they will ask the court to increase the level of fine headed down, especially for repeated offenders? You should remind the judiciary or your prosecutors what your intent of legislation is. Thank you. Well, I think that this is the responsibility of the administration. Thank you. We'll note your suggestion. Next, Mr. Benson Look. Thank you, Madam Chair. The government said that upon receipt of the comments of the operators, they reached out to them and talked to them. I recognize their efforts in this. I think that regular communication is key. I have two sets of questions for the administration. We need to be fair. The administration just now clarified that there is no unfairness in terms of the difference of threshold. Let me give you a description. An operator of Columbaria said that if operators applied for exemption early and they have their exemption approved, in that case, they will have to pay the annual fee earlier. In this case, it would seem that they pay more fees than those who apply later. Does this exist? I wonder what the administration's view is on this. Second, I put the same question in the last meeting. under the exemption mechanism, the Columbaria cannot sell any new niches. And some operators said that they want to pay the land premium to the government and be able to continue to sell niches. But then they heard rumors that they can only sell new niches upon removal of the additional structures. The administration said in the last meeting that they look into them on a case-by-case basis. I wonder if the administration can let me know if the operator can only pay land premium after removal of their additional structures. Deputy Secretary, thank you. I will confirm that the amendment will not cause any unfairness to operators. As for Mr. Look's description, I think that he was talking about the license holders because they obtained their license earlier. That's why they have to pay land regularization fees. But then after they have their license, they will be able to sell their niches earlier and they would earn more. For those who pay the fees later, they could only sell their niches at a later stage. This is the normal kind of business. For shops that open later, they only have to pay rent at a later stage. This is very normal. For people who obtain their licenses earlier, they will be able to sell more niches. As for the point about the removal of structures, I will ask the PCAO to supplement. This differs from case to case. The Buildings Department and the Lands Department look at all of the cases. I will ask the PCAO to elaborate. Mr. Chang, thank you. For those who have short-term tenancy, if they have illegal structures, as long as they obtain a license, they can keep those structures. But if they want to obtain a long-term tenancy, they have to work with the Lands Department to look into the nature of the structure. Mr. Luck, any follow-up question? No. Next, Professor Chairman Kong. Thank you. I have these questions. First, the bill relaxes the eligibility for 2 specified instruments. How can the administration make sure that the private Columbaria near private residential developments will not affect the environment in the vicinity? Also, I'm concerned about the efficiency of the government in approving specified instruments. As at 30th of November 2024, the administration approved 18 applications and issued exemptions and licenses. But there are still 78 applications that are still pending. Although in the government's reply, they said that they will further expedite the approval process on the application of specified instruments, they did not say clearly how long it takes for them to vet and approve all these applications. Do you have a concrete timetable? My third question, currently, what is the manpower of the PCAO? If the bill is passed, is the administration confident that the current manpower under the PCAO will be able to handle all the work relating to the approval of applications for specified instruments and enforcement?
Deputy Secretary, thank you, Chan. Thank you, Professor Chan. On the first and second question, I will give a reply. On the manpower situation of the PCAO, I will defer to the head of the PCAO. Now, we have relaxed the restrictions so that the option to apply for exemption be offered to operators of pre-cut-off private columbarium. This is not an unconditional eligibility. There are 3 conditions. 1, there is an application ongoing for a license or exemption. Second, the Columbaria cannot be located in a high-density residential zone. 3. As at the commencement day of the bill, there must not be a refused application from the operator of the precast of Columbarium by the Town Planning Board. This will ensure that we can strike a balance between public interest and the concern that an ash clearance operation would disturb the interred ashes. Now, in terms of the efficiency of our vetting process, as we said last time, the new option to apply for exemption is to address the historical issue of license or exemption application from precast of Columbarium. Now, the law was enacted in 2017. One of the most important objectives of the ordinance, which was also agreed by the then LegCo, was to deal with these precast of Columbarium with a compassionate approach. Now, there are still some precast of Columbarium in the process of applying for a license. That's why we would like to offer them the option to apply for exemption. Now, for operators who opt for this pathway, we will offer them a temporary suspension of liability instruments for 3 years. Now, if the Columbarium still fail to meet the licensing condition, we will offer one extension of the specified instruments. So in other words, there is a deadline set for the Columbarium to meet the licensing requirement. Ms. Charmaine Wong, thank you. There are some 60 colleagues in the PCAO for license approval, law enforcement, and administrative work. Now, for license, we have 2 teams of colleagues. One is for enforcement. Now, when there are more applications for specified instruments to be issued, we will meet the additional workload by flexibly deploying our resources internally from the enforcement team. Thank you. Any more questions from Professor Chen? The last member is me. Now, we have read the submissions and the government's replies. 2 submissions have different views on the bill. Now, for operators who have been operating the Columbarium for many years, of course, they would like to keep the ashes and safeguard the ashes for worshippers. So we thank these operators for their contribution. But how can we ensure that they can meet the new requirements under the law? I hope the government can do a better job in explaining the administrative procedures to them and to explain why the new arrangement is fair. Please address their concerns on unfairness. Now, of course, you said that if you obtain a license earlier, you can sell the niches earlier. But we need to trust the operators. They are very experienced in the business. When they raise a concern on unfairness, we really need the concern addressed by the administration. So among the 3 submissions, 1 is in support of the bill, 2 are different views. Now, their views have been set out on the paper. There are 3 main points. There is a controversy between the new and old arrangement. Now, they said that for precast of Columbarium, meeting certain criteria, they will be eligible for applying for exemption, and after being granted a specified instrument, they can continue to operate in a restricted approach. So they think there is a difference, there is unfairness between licensed and unlicensed private columbarium. Now, in the initial period, after the enactment of the law, because of the complicated law, the operators needed to invest a huge sum of money to fulfill the conditions, but there was no option to apply for an exemption. Now, the process for applying for the formal license is very complicated and very demanding. Now, they think it's unfair that you are only now putting forward this option to apply for exemption. If there was an exemption pathway back then, it would have saved a lot of the troubles. So that's why they think this is unfair. They have paid administrative fees and fines for the delay. They have paid fees to defer the application process. So in the end, they were imposed with a higher administrative cost. So this is unfair for them. I would like to ask the government how the burden can be relieved through administrative means.
當年個法例
Thank you for your question concerning the arrangements when the law was enacted. At the time, applications were made in accordance with the law, and we did provide assistance to those applicants. Now, for pre-cut-off columbarium, for an application made before June 2014 by way of short-term tenancy or short-term waiver, we have waived parts of the fees. So the arrangement is just the same. For niches sold before the cut-off date, fees would be waived. So the arrangement is aligned for those who choose short-term tenancy or short-term waiver. Now, for the claim that in order to fill the then requirements, expenditures was spent to fulfill the conditions. That was actually our intent. Now, 7 years on, we are aware that there are some columbarium operators which have encountered difficulties in obtaining a license. So one of our amendment proposal in the bill is to cater for the needs of this group of operators who still fail to obtain a license. We do not target the operators who have already obtained a license. We are offering an option to apply for exemption because we understand that if operators still fail to meet the licensing condition, then it may trigger a large-scale ash clearance operation, and that may affect public interest. That's why we are moving the amendments to meet the public's need and also for the convenience of operation of columbarium. Now, one must note that for those being granted a specified instrument or an exemption, new niches can't be sold. They can only operate according to the existing scale. For columbariums with a formal license, they are given much more flexibility. They can sell new niches, and there is much more freedom for them. So we cannot have a direct comparison. Ms. Rebecca Chan has pressed the button as well, but I will have a second round myself. Thank you, Chair. I'm also concerned about the manpower situation of the PCAO. You said one more team would be deployed for conducting inspection. After the new arrangement is put into place, we need to check whether there are still substandard columbarium. I've seen some columbarium operating in households. So in the past, have you had any difficulties in gaining entry to private premises to conduct inspection? In my constituency, that is Hong Kong, there are lots of columbarium or niches placed in private establishments or private premises. The cases are only reviewed during the Qingming or the Chongyang festivals. So in terms of the power to gain entry into private properties, what is your power? Now, the other piece of ordinance, for example, the ordinance addressing air conditioners, water dripping, the occupants of the premises are given a deadline to allow entry into the house. So do you have this similar power under the law? Now, I have logged onto your website. There is a timestamp saying that the web page has been updated, but the guideline is just a PDF. So there were criticisms that the users of your web page are usually aggrieved or bereaved families. So can you make sure that your web page is convenient enough so that the bereaved families can handle the entire funeral process easily? Now you are just putting out the information like a consumer's information. You have a map and you have the numbers and numbers of niches available. Now can you update the information more frequently so that they can get the most updated information? I know this may not be the responsibility of the government to provide the most updated figure of niches available, but can you get help from the operators so that the family members of passed away ancestors can find a niche easily? Deputy Secretary. Thank you, Chan. Thank you, Ms. Chan. Concerning the website, we will actively follow up on Ms. Rebecca Chan's suggestion. This is indeed an area which we can enhance. On law enforcement, may I defer to the PCAO? Thank you. On law enforcement, there are two approaches. One is acting on information or informants. Second, we would conduct online patrol for advertisements of niche sale. When there are suspicious cases, we will apply for a court warrant from the court to gain entry into the premises for evidence gathering. Now, according to the figure, in our past experience, we haven't encountered major issues in gaining entry into the premises. Thank you.
我本人嘅。
Now it's my turn. I have a follow-up question. In the comments given by the operators, they said that extending the deadline of exemption application until 30th of June 2027. If the licensees can prove that they have stopped selling niches, then they should be given the opportunity to apply for an exemption instead. What is the government's view on their suggestion? Thank you, Madam Chair, for the question. The PCAO has talked to the relevant operator. We try to understand why they gave such a suggestion. As I mentioned in my opening remarks, they made such a suggestion because they had a misunderstanding. They thought that the niches sold between the 18th of June 2014 and 30th of June 2017 can be exempted from land premium. But the truth is that they are not exempted. Applicants that have been granted an exemption will still have to pay the relevant regularization fees. So there is not a difference between a license holder or exemption holder. Holders of exemption will not enjoy any benefits. Operators with licenses won't have the incentives to apply for exemptions. Some operators told me that the time taken to obtain an exemption and license is very long and the procedures is very cumbersome. Can you streamline the application process so that operators can apply for the specified instruments more easily? Thank you. We do note the problem, and we have adopted various measures to streamline the vetting and approval process of the applications. We have case managers, we have specified agreements. In the coming 3 months, all case managers will review with the applicants their committed action plans, and the case managers will also organize interdepartmental meetings. We will also roll out a new mechanism because we need different departments and bureaus to provide their comments on the applications. Under the new mechanism, we require all relevant bureaus and departments to an application to provide within 3 weeks from the date of circulation their comments on the documents and information submitted by the applicants. If they are not able to submit their full comments within 3 weeks, but only initial comments, then they have to explain why full comments cannot be provided. We ask these relevant bureaus and departments to give all of their comments in one go and avoid giving comments by batches, because this will make things very difficult for the applicant. We believe that the application process will be streamlined. Well, I also received other comments on how the Town Planning Board obtain the public's comment. Actually, Prefect Columbaria asked the residents in the vicinity whether they object to their operation. But sometimes Town Planning Board rejected the application because of objections coming from the vicinity. But then some of the Prefect Columbarians said that they have actually consulted the nearby residents, and some of them actually existed before there was any residential developments in the area. So their question is, how can we reassure that the Prefect Columbaria have all the information and feel that the Town Planning Board's decision is fair to them? Thank you. On the vetting process of the Town Planning Board, well, they act on the Town Planning Ordinance to vet all the applications. They have a very transparent mechanism to collect public comments and views, and their meetings are also open to the public. I believe that the decision of the Town Planning Board are uploaded onto the internet. The TPB does not only scrutinize applications from private Columbaria, they also work on different land uses and across the territory. The work of the TPB is very well recognized. We believe that the Town Planning Board's decision would have had regards to all of the factors, including the residents in the vicinity, the applicants, and the compatibility with the vicinity. Any other questions? If not, we proceed to clause-by-clause examination. let's look at CB bracket 2, 68 2025-01. The LSD have also prepared the marked up copy. Would the administration lead us through the clause-by-clause scrutiny? As for the by the end of the clause-by-clause examination, I will ask the legal advisor for their comments on the translation. First, on the long title, there are 6 parts to the bill. Part 1, it will allow the Prophet Columbaria to apply for exemption. Part 3, amendments relating to offenses and penalty. It has to do with offenses relating to sale of interment and interment of ashes exceeding ash interment capacity and not covered in approved plans. Part 4, amendments relating to Prophet Columbaria Appeal Board. Part 5, amendments relating to Masons workshops. Part 6, amendments relating to company secretary. I will first talk about the long title. The short title is "This ordinance may be cited as the Prophet Columbaria Amendment Ordinance 2024, Clause 2. The Prophet Columbaria Ordinance is amended as set out in Parts 2 to 6. Now we come to Part 2, amendments relating to application for exemption. Clause 3 of the bill has to do with amendments to some of the definitions. The definition of enactment date is 30th of June 2017. Under subclause 2, we will add the definition to specified date, which means that the date on which the ordinance will come into operation. Can you let us know which part you're referring to? Because I'm reading the blue bill and I'm also looking at the marked up copy. Can you tell us which page you're on in the blue bill and also the marked up copy so that we can go through them clause by clause? Are you introducing the bill or are we scrutinizing the bill? I'm at C2787 of the blue bill. We should look at it clause by clause. When you talk about the long title, can you lead us in it? And I will open the floor to questions from members. C2783, preliminary. Any question? If not, we proceed. Clause 1. This is the title of the ordinance, that is the Prophet Columbaria Amendment Ordinance 2024. No question. Clause 2. It is said that the ordinance amended are set out in parts 2 and to 6. Clause 3. This is to amend the definition of enactment date. After the date, we'll add, that is to say, 30th of June 2017. Legal advisor? No. Any questions on clause 3? 4. Subclause 2, we will add specified date. That is the date on which the Prophet Columbaria Amendment Ordinance 2024 comes into operation. Clause 4. Clause 4. We amend Section 14. First, we will amend Section 14, bracket 6, bracket B. we changed the Chinese expressions. We changed the order of the two sentences in the Chinese text. The meaning remained the same. This is page 10 of the marked up copy. Any question? Clause 5. We will add section 14A. It's about the specified period for specified instrument or exemption. We'll add section 14A bracket 1. It empowers the licensing board to make a specified day during which exemption application can be made. 14A, any question? Legal advisor, any question? Mr. Tony Chair. Thank you, Madam Chair. It says here, an application for the issue of an exemption in respect of a pre-cut-off Columbaria may also be made after the specified date and within a period to be specified by the licensing board. As mentioned, we are not going to extend the period any further. Is it because you are concerned that you will not be able to process all the applications despite the extension? That is why you empower the licensing board to specify the period. Thank you, Mr. Chair. The specified date or the period is for us to receive or collect new applications for exemption. During the initial stage upon enactment of the bill, the specified period will be 3 months. We allow the licensing board to specify the period for collection of new applications. This is a period for collecting application but not scrutinizing application. Well, operators can continue to drag if they don't make any application. Can the licensing board extend the period for vetting the application indefinitely? Regarding the exemption, there is a temporary suspension of liability. They have to renew it once every 3 years, and it can only be renewed one time. Before the second temporary suspension of liability is ended, the applications have to be scrutinized by the licensing board. On the point about extension of the specified period, I hope that the period will not be extended indefinitely. Is there a deadline? After an application for exemption is filed, is there any deadline before which the licensing board must grant or refuse the application? I hope that there will not be indefinite delay.
咁首先呢，就係想講講呢。
Deputy Secretary. First of all, we are now offering an option to the Columbarian operator who are now in the process of applying for a license.
重要嘅一個商業決定嚟嘅。
This is a very important business decision because with a license they can continue to sell niches. We will give them sufficient time We will also send our case managers to explain the arrangements to them so they can make an informed decisions. Now, the licensing board is a statutory body with sufficient experience. They will decide a reasonable period for the operators to submit applications. Of course, we will not allow indefinite extension to the operators. Now, also, in the previous round, the licensing board has granted 3 months for the applicants to apply for an extension. So what do you think a reasonable period is? If 3 months are too short, will you give them 9 months? And do you have confidence that you can process all the applications in 9 months' time? For more complicated cases, it may take more time. But I would like to know how much extension you would allow. Deputy Secretary. Thank you, Chen. Thank you, Mr. Jie. Under the law, it is the licensing board which has the power to grant an extension. Of course, we will issue a guideline for the reference of the licensing board, but we do think that 3 to 6 months would be reasonable. For cases where there is a genuine need of extension, the licensing board will extend the duration on a case-by-case basis. Mr. Chair, no follow-up questions. I have some questions as well. Now, the legal advisor has asked a similar question in relation to the specified time, 14A. What is the duration of the specified time, and how can we communicate the time frame to the Columbarium? Now, according to your reply, 1A, pre-cut of Columbaria must apply for the issuance of a specified instrument within a 3-month period ending on the 29th of March 2018. From operation experience, the said arrangement was smooth. Now, the licensing board would specify the period for pre-cut of Columbaria to make new applications. And also, relevant factors, including its past operation experience, would be considered in determining the length of the specified period. So the specified period is not a fixed period. So I don't think that is very clear. You would do better to say, please refer to a time frame announced previously. That would be clearer. Now, in terms of Section 14A of CAF 630, we stipulated that the period would be designated by the licensing board. So the licensing board would make a decision after a decision is made. The decision would be conveyed to the public and the operator of Columbarium via various means. So there should be a clear communication of the decision made by the licensing board. It would be announced through various means. So in terms of the articulation, would it be clearer if you say that in accordance with the decision made by the licensing board and conveyed or announced through the FEHD, would it be better if we include this clause in this provision in the ordinance? Now, the licensing board will convene a meeting and make a decision and convey the message via the FEHD. So if the licensing board has made an announcement but the FEHD did not, it may cause confusion. People don't know which authority to rely on. So it would be better if the provision says that the decision is to be made by the licensing board and an announcement must be made by the FEHD. Thank you, Chair, for your reminders. However, according to the law, the power is clearly vested with the licensing board, but not the PCAO or the FEHD. So our job is to communicate that decision to the public only. So we consider the ordinance to be clear enough, and we will communicate the decision via various means. Thank you. Please move on. Section 14A, brackets 2. Reference has been made to the existing 14, bracket 6 on dealing with application out of time. Now, if the 3 months period is specified by the licensing board, say for example, for receiving application of exemption, application out of time means an application filed after 3 months' time. So we include 14A brackets 2 to give power to the licensing board to consider these applications out of time, but there are strict conditions. In 2A, we said that the applicant must have a reasonable excuse for failing to make the application within time. And B, the licensing board must consider all the circumstances of the case and considers that it is just and equitable to consider the application. Any questions about 14A brackets 2, applications out of time with reasonable excuse? Who is the one to decide whether an excuse is reasonable? So will the applicant be required to make a submission on application out of time and give a reasonable excuse? An applicant may feel that an excuse is reasonable. So maybe you should say specifically the reasons for making an application out of time. Everyone would think their reasons reasonable. So you can't act on the behalf of courts. So maybe you should say that the applicant needs to provide a reason for the application out of time. Now the existing 14A brackets 2 is identical with the existing 14 bracket 6B. So we will deal with application out of time under the existing mechanism. On who is it to say whether an excuse is reasonable? Now, the licensing board, as a statutory independent body, has the power and the experience to consider whether the information submitted are reasonable. Now, this mechanism has been running effectively, so we think we can keep the existing articulation. Thank you. Any other questions? Please move on. Clause 6 of the bill, adding the new Section 20A, conditions to be met by pre-cut-off columbarium for applying for an exemption. 20A brackets 1A, requiring pre-cut-off columbarium to meet the existing requirements under Section 20 in applying for an exemption. Now, according to our reply to the legal advisor, the new Section 14A and 20A in relation to application for exemption are based on the existing Section 20. Now, for the benefits of the pre-cut-off columbarium, we will adjust the requirements and introduce a presumption. Under the presumption, we will replace the interpretation of the date on which operation began from the 1st of January 1990 to the 18th of June 2014. Any questions on this part? Legal advisor, please. Thank you. According to the administration's reply, the government would move amendments to the proposed Section 20A. May I invite some clarification from the government? Thank you. Would you please explain the amendments, because that is also included in your reply? Thank you. We propose to introduce committee stage amendments to Section 20A. And the reference in new Section 20A will also be incorporated into Sections 27 brackets 4, 40 brackets 2A, and also Section 84 brackets 1A, and also Section 104 to D. The reference of new Section 20A will also be incorporated so that the public can understand that the new Section 20A's provision about application for exemption also apply to these sessions. Thank you. Any questions about Section 28? Please move on. Clause 7. Amending Section 55, the heading. Interment of ashes. Interment rights sold before cut-off time. We will repeal before cut-off time to cover niches sold after the cut-off time. Sorry, Ms. Lau, let's go back to Clause 6. We haven't completed the entire clause. Section 20, brackets 1b, that is C2791 in the blue bill. That's 20A, brackets 1b. 3 conditions to be met to apply for a license, or rather the exemption. That is, an application for the issue of a license made by the applicant is still being processed. And second, the columbarium is not located in a zone or district designated as residential group A. And 3, conditions in relation to planning. Thank you. Any questions on B?
冇，下一部分。
No. Subclause 2, please. This is about conditions for planning application. The first condition is that the planning application in respect of the Columbaria has been accepted or granted by the Town Planning Board, regardless of whether or not there had been any other planning application in respect of the Columbaria that had been refused. The second condition is that no planning application in respect of the Columbarium has been refused by the Town Planning Board. Any questions? No. Subparagraph 3. This is to explain what the cutoff time at the beginning of the enactment date are. The cutoff time is replaced by 18th of June 2014. The subparagraph B apply in relation to the application as if the words beginning of the enactment date were substituted for the words of cut-off time in those sections. They will cover 23 bracket 1 bracket B bracket 2, 24 bracket 1 bracket A and bracket B, and 27 bracket 1 bracket C bracket 1. Any question? If not, please proceed. Subparagraph 4. We explained about the planning application conditions set out under section 20A bracket 2. Here we talk about what sections under Cap 131 are being referenced. Any questions? Not. Subparagraph 5. It says that if the licensing board grants the application made, then the applicants must fulfill certain criteria or conditions, as we have adjusted the pre-cutoff time under section 54 bracket 2 and section 55A. We have to replace the pre-cutoff time with a beginning of the enactment date. No question. Now we've come to subparagraph 6. These are the new definitions under section 20A. They only apply to section 20A. We want to explain about some of the definitions under town planning ordinance to make things clearer. Any questions? Clause 7. Now we proceed to clause 7. We repeal before pre-cut-off time under section 55. It shows that the interment of ashes by exercising interment rights sold before cutoff time are covered. Any questions? Part 3. There are amendments relating to offenses and penalty. Clause 8. We reflect the licensing conditions under section 30 and introduce offenses relating to selling of interment rights. We're going to amend the heading and add after interment, sale of interment rights. Subclause 1, no question. Subclause 2, please. After section 30 bracket A, we are going to add some new provisions. AB is about the number of interment rights that is sold in respect of the Columbaria, and they must be limited to the capacity shown in the approved plan. AC, it says that the license holder must not sell any interment right in respect of the Columbaria other than those shown on the approved plan. AD, the license holder must not inter ashes or cause or permit ashes to be interred in a niche other than a niche that is shown in the approved plans. AE, the license holder must not sell any interment right without an authorization under the license to sell the interment rights or when their license have been revoked or suspended. Mr. Lam San-Ken, what does capacity mean? It means the number of niches that can be placed Are you talking about the total number of niches? Number of sets of ashes. So you're referring to the number of sets of ashes? I'll ask the PCAO to answer the question. Thank you, Madam Chair. Regarding the capacity, that is the ash interment capacity, it means the licensed Columbaria and the layout plan are granted by the licensing board, and in each of the niches they can place various sets of ashes, because some are single niches, some are double niches. By capacity, we mean the total number of sets, total sets of ashes. So we're not talking about the total weight of the ashes. We're talking about the unit. Yes. Mr. Tony Che. Thank you. I'd like to ask about the capacity. Will you allow the operator to expand the capacity? Now, it's a trend that couples place their ashes in the same niche. Is there any flexibility in this, Mr. Che? When the operators apply for licenses, they have to set out the capacity for each of the niche. Are they single or double niches, or niches for 8 sets of ashes? After the application is made, if they are pre-cut-off Columbaria, we have to look at one more thing, that is whether the layout plan fulfilled the 2014 conditions. After the applications are approved by the licensing board, then the information of the niches, that is the number of niche ashes that can be interred in a single niche, are all the conditions that the operators have to fulfill. Madam Chair, regarding the approved plans, the capacity is shown. What if a Columbarium has already oversold their niches? Then their capacity would be larger than what is usually approved. Mr. Chang. Thank you. When they make the application, they have to make sure that the capacity is proper. And this will become one of the licensing conditions after the application is approved. We have our colleagues who will patrol the Columbaria to make sure that the conditions are met. Mr. Chair, I'm talking about the approved plans. What if the operators are already overselling their niches when they make the application? Would it happen? Mr. Chang, no. We have not seen any such cases. When we scrutinize the application, we look at all the niches in the Columbaria to make sure that the capacity is the same as shown in the approved plan and the actual site. Say if the operators oversold the niches when they make the application, they violated the laws because they didn't comply with the capacity as shown in the approved plans. We have not detected any such cases. No questions? Next clause, please. Madam Chair, we are going to move a committee stage amendment on Section 38 to set out clearly that the licensing board is empowered to impose conditions restricting the imposition of additional fees not specified in any agreement for sale of interment right entered into before the enactment date. Can you speak up how you're going to make, what amendments you're going to make? Under Section 38 is about additional fees and the conditions. It says that when the licensing board deems appropriate, they can impose additional conditions and restricting the imposition of additional fees. Excuse me. Under this amendment, the licensing board will have the authority to impose conditions. But in the existing legislation, we only talk about agreement for a sale of interment right entered into the enactment date to make it clear for the consumers. We will cover the pre-Gazetted agreement. Will you give us a set of paper on the CSAs that you're going to move? Because we don't really get it. Ms. Law, thank you. Yes, we will. Because we have received comments from the legal advisor and we're going to introduce CSA. All the CSAs are to make things clearer. When we drafted the bill, we thought that our bill was clear enough, but the legal advisor thought otherwise. We respected their views, and that's why we proposed to introduce the CSAs. We're going to say add Section 24A to many of the clauses. As for Section 38, it sets the interment right entered into before the enactment date, and only on those rights do the licensing board have power over. But if for the time period, we're going to amend it to niches sold before 30th of June 2017. Most of the amendments are rather simple. After the meeting, we're going to supplement with a paper on the CSAs that we're proposing to introduce. Thank you. If I may remind members that the Section 38 amendments that they're proposing is set out in paragraph 2 of the legal advisor's letter and paragraph 3 under their reply. Let's proceed to the next clause. Clause 9. We are going to amend Section 54. We're going to introduce offenses relating to the sale of interment rights. We're going to amend the heading. After interred, we're going to add a number of interment rights sold. Yes? Any question? We're talking about page 23 of the marked up copy and C2799 of the blue bill. No question. Next clause, please. Subclauses 2 and 3 are here to rationalize the writings. We repeal everything after then in niches and substitute it with and the number of interment rights sold in respect of the Columbaria are limited to the ash interment capacity shown in the approved plans. Mr. Tony Che. Thank you. Can I go back to page C2797 or page 22 of the marked up copy? I'd like to ask about paragraph 8C, that is the sale of interment rights. Will you impose a time limit for the sale of interment rights? If I sell a niche for placement 10 years later, will it be in compliance with the laws? That is, the rights or interest is only invoked after a period of time.
或者
Ms. Cole, may I defer to Mr. Chang? Mr. Francis Chang from the PCAO. The validity of the interment right depends on the tenure of the land lease. If the land lease is valid until 2047, the same will apply to the interment right. In terms of the validity period of the interment right, we will look at whether there were occasions where the approved ash interment capacity has been exceeded. Of course, the Columbaria operator has no right to sell an interment right beyond the approved period. If an operator sells an interment right beyond the validity period of the land lease, the consumer has the right to request for a refund. So the maximum tenure of the interment right is dependent upon the land lease. So can I say sell an interment right 10 years in the future? In the next 2 or 3 years, the operator may sell interment rights after the 10 years. Of course, you cannot exceed the tenure of the land lease. But have you required that the length of the interment right must be the same as the tenure of the land lease, not a day shorter? Thank you. I think the concern arose from Section 30AC. That is Clause 6, Section 30, brackets 2AC. That is about the interment right as shown in the approved plans. Now, in our consultation process, we realized there were concerns about exceedance of the approved ash interment capacity. And second, the locations, the exact whereabouts of the niches according to the approved plan. So as you may know, that the prices for niches may differ according to the locations of the niche in the Columbaria. So AC is about sale of interment rights according to the plan. AD refers to ashes interred as shown in the approved plans. So concerning whether an operator can sell interment rights for a certain time period, I would defer to the PCAO. Thank you. Now, having considered the approved interment capacity and the approved plan, each operator can decide how many niches to sell according to the business plan. But we have capped the total number of niches they can sell and also the information about these niches on the plan. Chair, I think you understand my question. The interment right comes with an expiry date. So let's say an operator has sold all the interment rights within 5 years' time and the capacity has been reached. Can I sell interment rights after the 5-year period in advance? So do you mean whether the interment right is transferable? No. Can I sell an interment right shorter than the land lease tenure? Or is there a restriction that the tenure of the interment right must be the same as the expiry date of the land lease. So of course you can't exceed the expiry of the land lease, but what about shorter than it? So would that give rise to a situation where the operators are selling interment rights in advance? So if the land lease is 50 years in tenure, can the operator sell the interment rights by batches of 5 years? Now let's say the land lease tenure is 50 years. Can the operator sell the interment rights by batches of 5 years to different individuals? Now, first of all, the operator has to ensure that they have not exceeded the approved capacity. If they sell 5 times the interment rights, then of course they are breaching the law. Now, if they sell interment rights 10 years in advance, now as long as the existing capacity is not exceeded and that the plan is not breached, then according to a private agreement, if the first user or the first buyer would clear the niche within 10 years' time, and then the niche can be sold to the next buyer, then that is allowed under the law. But that's dependent upon the agreement made with the buyers. So to a certain extent, there is regulation. So for those niche sold with a 10-year period, the buyer will have to vacate the niche so that the niche can be resold. Otherwise, the approved capacity would be exceeded. So of course, that's another thing in reality. An interment right of 10 years and 30 years would come with very different prices in the market. But we can't assume that that is not a possible scenario. Now, if that's the case, it may give rise to a very confusing scenario, especially to the buyers. Now, of course, some buyers who are younger may have no problem buying an interment right 10 years in the future. There may be such a market for future interment rights. However, according to the government, it seems that it is allowed by the law as long as the approved interment capacity has not been exceeded. Now let me phrase the question more clearly. Interment rights and capacity. The operator has to comply with the law in both aspects. I think Mr. Jie's question is whether I can sell future capacity to buyers. The buyer isn't using the niche in the first before the relevant period. So can the niche be offered for sale to others before that period starts? So do the operators have to comply with both aspects so as to not to commit an offense? Thank you. There are two timestamps. One is the sale of the interment rights. The other is the time of interment. And the third factor is the approved plan. At the time of sale and the time of interment, the total capacity cannot be exceeded. And on both occasions, the ash must go to the niches according to the approved plan. Now the question was whether a sales of interment rights future is allowed. Now, at the sale of the interment right, the total capacity cannot be exceeded, nor can the approved plan be bridged. Now, before the reference period starts in the interim, the niche can be sold to another person. That is allowed under the law. Mr. Zhang. Thank you, Chair. 13 licenses have been granted. Now for prepayment, for sales involving prepayments, the validity period of the interment right is aligned with the land lease. So the scenario you mentioned of breaking down the sales into batches of year has not been seen. Now, when ash is interred in a niche, usually another person would not purchase the niche because usually people would prefer a new niche. Now, we cannot rule out the scenario mentioned by the Deputy Secretary, but in reality, it has not arisen yet. Chair, I asked my question because when you look at the approved capacity, agreement also counts. So in terms of agreements, you can make a pre-sale agreement. I'm just trying to see whether there would be any inconsistency in terms of how the period is counted. So it seems that the situation has not occurred yet in the market. Well, but if you look at the public columbarium, the tenure is 20 years. There is always a possibility that the extension is not granted. Of course, usually it would. So when the previous occupants of the niche has moved out, even so, buyers may prefer a new niche. That's true, but there is a time limit for government-run columbarium. In the market, I think an interment right of 20 years would be different from that of 30 years. So, of course, the difference would be reflected in the price tag. I'm just bringing up this question because public columbarium comes with a time limit, so it can't rule out the scenario entirely. Thank you, Mr. Chen. We agree that the scenario mentioned by you is possible. However, according to the operating experience of the PCAO, it has not occurred yet. Second, about public columbarium. So far, the tenure is 20 years with possible extension every 10 years' time. The fee is half of the first 20-year period. So if the descendants of the descendants want to extend the period, that's allowed. Please move on.
Now let's move on to Clause 9, Subclause 4. We're going to introduce new offences. That is, holder of a license must not sell any interment right other than interment right in respect of the niche that is shown in the approved plan, and the holder of a license must not inter ashes or cause or permit ashes to be interred in a niche other than a niche that is shown in the approved plan. We are at C2801 of the Blue Bill. Any question? Not, please move on. Now we've come to subclauses 5 and 6. They have to do with the newly introduced offences. We are proposing to introduce a penalty. we will increase the penalty to on summary conviction to a fine of $2 million and imprisonment of 6 months, and on conviction on indictment to a fine of $5 million and imprisonment of 2 years. Mr. Lam San-kun, thank you. I'd like to ask Section 54, bracket 1. It talks about capacity, sets of ashes, so on and so forth. All we're talking about is niche. Am I right? Regarding the number of internment rights, I think you're referring to the number of sets of niches in ashes in a single niche. The denominator is the capacity, and the numerator is the number of internment rights. At the end of the day, are we talking about the number of niches that we have in a Columbaria? Ms. Law, thank you. We need to clarify. In a single niche, we can have 1 or 2 or 4 or 8 sets of niches or ashes. So in terms of capacity, we have to look into the number of sets of ashes kept in a single niche. So we're not just talking about number of niches. For the number of internment rights, we're talking about the number of urns that we see. Is that right? You use numerous wordings to talk about the same thing. PCAO, Mr. Chang, please. Thank you. The number of internment rights are the same as the number of urn because usually there is only one set of ash in a urn. But in a niche, there could be 2 urns. What we're talking about is that we don't look at the number of urns because some ashes are kept in a bag. So there are 3 things that we have to look at. First, the number of niches. Second, the number of sets of ashes that can be kept in the niches. So we don't just look at the number of urns because ashes can be kept in a bag. By multiplying these 2 things, we arrive at the capacity for the Columbaria. So if we multiply the number of sets of ashes with the number of niches in the Columbaria, then we will be able to arrive at the capacity of the Columbaria. We don't look at whether the ashes are kept in an urn or a bag. If not kept in an urn, then in what? In a bag. Perhaps I was not clear enough. My apologies. Any follow-up question? If not, let's go to the penalty. Ms. Chan Hua-Yan, please. Please turn on her microphone. Thank you. I'd like to write on Mr. Lam's question. Sometimes in the bill we talk about number of internment rights. We sometimes talk about capacity. I think that all we're talking about is the number of ancestors kept in a niche. The only difference is whether the ashes are kept in a bag or an urn. And the Deputy Secretary said that in a single niche we can have 4 or 8 sets of ashes. The question is with the capacity. Do we look at the weight of the ashes or the number of internment rights? Why don't we just say the number of descendants kept? Say in a niche there can be ashes of 3 descendants kept. In that case, we don't have to look at the, say, number of internment rights, the capacity. I think that's the question of Mr. Lam. Because sometimes we talk about internment rights, sometimes we talk about capacity. Say if there are 40 niches in the Columbaria and 80 sets of caches can be kept because some of the niches are double niches. We can say instead number of ashes of descendants or ancestors kept. That would be clearer. Ms. Law, thank you. The member asked about interment rights and capacity. Well, this is an amendment to the ordinance. In other parts of the ordinance, we also talk about capacity and interment right, and the operators are well versed of the ordinance. So we don't propose to make any unnecessarily major amendments to the ordinance, because these words capacity, interment right are included in many parts of the ordinance. We think that we should adopt the wordings used in the ordinance. As for the question about capacity, we do have a definition for interment right under the ordinance, and the ashes are also defined under the ordinance. They are clear, and the operators know these terms very well, so we propose to keep the existing wordings. Thank you. Ms. Chan. Now, if that's the case, I believe that other than operators, members of the public should be aware of the content of the bill. In the future, will you make the ordinance more readable? We will keep note of that. Thank you. Next, Mr. Paul Chair. Thank you, Madam Chair. I hope that you don't mind my analogy. If we say sell property, we don't look at the number of people in a single apartment. After all, the price is the same. I think that we should allow the operators or the bereaved family the flexibility to decide on the number of ashes kept in an urn or niche. And as mentioned, some people prefer bags to urns to keep their ashes. Now, writing on this issue, why do we have to be so strict with the number of sets of ashes kept? Do the consumers have a choice to keep, say, 2 sets of ashes in a single niche to save money? Second, on the level of penalty. When LegCo scrutinizes government proposal to increase penalty, well, the proposal is tabled usually because there are a lot of people committing or violating the laws. Do we introduce this offense or increase the penalty because we have seen a number of prosecutions, or are there a lot of operators violating the laws? We don't want our policy to be penalty-led. I wonder why the administration make the adjustment that imprisonment terms changed from 6 months to 2 years. This is a 4 times change. Well, there are only 6 minutes left. I'd like to complete the scrutiny of part 1. Let's extend the meeting to 12:15, because Ms. Jovi Chan would also like to put question. Please answer Mr. Chair's question. Thank you, Madam Chair, and thank Mr. Chair for the question. Let me address the issue about penalty. Mr. Chair also talked about this in the last meeting. He said that our penalty is too high. I'd like to now take this opportunity to explain to you and the members of the public why our proposal is as it is. We have considered a number of factors. First, the potential profit is huge. As mentioned, the single niche can cost $300,000, double niches $400,000. If you oversell a few niches, the potential profit is substantial. Second, we look at the impact cost to the people. Some senior citizens want to purchase a niche for them to keep their ashes after they pass away. That's their wish. Now, if due to various reasons the niche cannot be sold and the ashes of the deceased person cannot be interred, this will become a great problem. Third, some of the penalty level is too low. Say, for example, for the overselling or overplacing of ashes, the current penalty is only $3,000. Fourth, we have not seen a number of too many violations. We believe that the Columbarium operators are honest businessmen, but we don't want to deal with the issues only when it arises. We want to be forward-looking. We want to prevent any violations from happening. Lastly, we have conducted a public consultation on the penalty level. Over 80% of respondents actually support the proposed penalty level. So we think that level is appropriate, and I hope that the Bills Committee will support it. Mr. Chair talked about the sets of ashes in a niche. Well, in public columbaria, we look at the size of the niche to determine the number of sets of ashes that can be kept. Because public columbarium is funded by public money, we want to make the best use out of it. That's why we try to be more flexible. But as for private columbarium, especially those pre-cut off ones, they are located at residential areas, especially those with exemptions. If we don't set a limit on the sets of ashes that they can keep, it will affect the traffic and transport in the vicinity, and that's why we think that we have to regulate them. Thank you, Mr. Chair. Madam Chair, let me address the second point. If the government has such a flexibility, why don't you also allow the consumers to make a choice? For regular property, you don't restrict the number of residents in a single apartment. Say for public rental housing, you don't impose such restrictions. You shouldn't impose the same restrictions on private residential development. However, under the bill, you said that if you don't set the limit for private columbarium, then the traffic in the vicinity will be affected. I don't think that's reasonable. For the 5 points that you mentioned, you said that you have consulted public consultation. Some 10 years ago, well, when you first drafted the ordinance, you have already set the penalty level. You should have considered the huge profit involved and other factors. When we draft a new ordinance, we have to look at the impact cost to the society. It's not reasonable for you to impose a death penalty on abuse of a new type of dangerous drug. Is it necessary? This ordinance has been enacted for some 10 years. You said that other than operating a columbarium without a license, there's no many operators who have violated other offenses. We shouldn't be increasing the penalty by 4 times just because the potential profit involved is substantial. I don't want to adopt extreme means in order to ask you to compromise. Are you encouraging the operators to obtain a license, or are you encouraging them to give up?
我睇唔到。
Thank you, Chair. Thank you, Mr. Chair. First of all, I don't see any earnest operators of Columbarium having to close the business just because of our law amendments. And second, we share the same view with Mr. Jie. Proportionality is very important. We agree and respect Mr. Paul Jie's analysis. Now, the reasons I listed just now, those were the factors behind the introduction of the legislative amendments. We think it is proportional because of the potential financial gain and the impact on the public. We didn't just conjure the penalty ourselves. We have compared the penalty and found them to be consistent. Now, these penalties are lighter than Section 11 of the ordinance. So even within the same ordinance, it is proportional. Now, we emphasize the spirit behind the enhancement of the penalty, and we urge members to support our amendments. Ms. Jovi Chan, thank you. About using the number of units to calculate the penalty. Now, since we are amending the law, we would like to make the wordings consistent so as to avoid different interpretations by individuals. Now, proportionality and strictness is a consideration. Consistency is also a consideration. For houses for the living, we use the size, the floor area, as a means of calculation. For flats for the departed, you use capacity in calculation. Now, Section 5A, in the definition for stone masonry, sometimes you use the word capacity, but in Section 4C, you use the word portion of ashes. So there seems to be an inconsistency. Since we are already amending the law, let's make it more clear and consistent to avoid misunderstanding. Any reply from the administration? Yes, I thank Ms. Jovi Chan for her views. As I've mentioned, this is an amendment bill, so we will try to adopt the original wordings in the ordinance as much as possible. About mason workshops, the arrangements, mason workshops are not covered by the ordinance. They are not a kind of private columbarium. Professor Chan, thank you. About the number of portions of ashes to be placed. If a family has purchased a niche for the entire family, how do you calculate it? In terms of ash capacity, sometimes buyers of niches would place clothing or other belongings of the departed in memorial of the departed instead of the ash. So how do you calculate it? Now, buying a niche is just like buying a private property. For those who have less financial means, they may purchase a niche for the entire family. So would that be allowed in the law? Now, in terms of traffic impact, I don't believe that a columbarium would lead to traffic congestion. It's just the families who will visit. Deputy Secretary, thank you. Now, approval given by the Town Planning Board is a very mature decision. Now, whether a columbarium is allowed to operate in an area, the TPB would make reference to the traffic impact assessment report. Now, if a niche have many urns placed in it, then maybe the extended family members will also come to visit. So there are all sorts of scenarios possible. That's why in dealing with application for Columbarium land use, the TPP would also look at the traffic impact assessment report. And once again, the buyer of the niche, the operator of the Columbarium, for private Columbarium, they must have some traffic plan in place. And also we need to cater for the needs of the neighborhood. So we think our existing plan is appropriate. Now, when it comes to traffic, you need to give us data. You are not able to convince us because we don't think that a flags for the departed would lead to traffic congestion. No one would believe that, sorry. So please reconsider your position. Thank you. Professor Chan also mentioned about articles placed in the niche. Yes, what about articles other than ashes placed in the niche? Mr. Zhang? Now, in the law, we set out the approved capacity and for ashes. Now, for articles placed in the niche, that will be outside the scope of the ordinance. Of course, a buyer can place other articles in the niche. However, if ash is placed, they need to fulfill the requirements under the license. Now, because your bill uses ash capacity as a definition, now if other items like clothing are placed, then the law will not apply. So you need to be clear. We understand that there are new practices like making ashes into diamonds. So you can place many diamonds in the niche. So it depends on the practice of the Columbarium operators. Do they set any restrictions on items to be placed in the niche? So may I invite some comments from Mr. Zhang because you are the expert. Thank you, Chair. As we have said, we only regulate the number of ash urns placed in the niche. Of course, other articles can be placed in the niche, but that would not be against our regulation. Mr. Paul Chair. I don't know how to put it. For many years in the past, I have been following on the issue as a council member. The original ordinance has received a lot of debate, and it took a long time to pass. Now it seems that you are still playing it by the book after so many years' time. I agree with Ms. Jovi Chan or Professor Chan. The TPP only refers to the traffic impact assessment report. Now, if you are worried about congestion caused by flags for the departed, or maybe you should ask the TPP to consider how many extended families will visit the living members of the families in the house every year, especially during summertime when students have summer holiday. It seems that you have run out of reasons. That's why you are sticking to this one. Now you are amending the law to extend the exemption period. It is very unfair to those operators who have already obtained a license. Some of my colleagues say that this may be subject to judicial review. Because of your initial policies, you have strangled the market. It seems that you are very scary. You're very scared of having more Columbarium operators in the market. How much money the operators make is of no concern to you. If that's the case, maybe you should impose more fees on private family doctors, well, lawyers are doing poorly now, so maybe doctors can give you more revenue. So your mindset shouldn't be trying to strangle an industry. There are no evidence showing that there is abuse in the market, so you shouldn't calculate this. Well, how about we calculate how many civil servants are slacking on the job? If you are doing that, it would cause a lot of disputes in society. Sorry, I mean no offense to anyone. But as a policy setter, policy maker, you should try to be more relaxed unless there is a problem. Then you can legislate for harsher punishment. You shouldn't enhance the penalty just for the sake of tidiness. You are saying that the punishment for non-licensed columbarium is hefty, so you need to align the punishments with those for licensed columbarium as well. That shouldn't be your mindset. If that's the case, you need to rewrite all the law. Thank you. Let's extend the meeting by a little bit. Mr. Portier, do you require a reply from the government? Well, I believe my views came too late, but I'm just trying to address the wider picture. The draconian punishment is making everyone sad. We are not like previous dynasties where any minor offense would come with a capital punishment. Thank you. Now, in terms of the fraction and also the capacity, please consider the stakeholders' views and take into account of them. So any more views on Section 9, of Clause 9, Bracket 6, in terms of the fine and imprisonment term for summary conviction and conviction on indictment? If not, then we have completed Division 1. We will continue with Division 2 and the other parts the next time. AOB, there is no AOB. Meeting is adjourned.